Please get ready for a dictation of exercise number 29 from legal material. 5 seconds. Start. In order to satisfy ourselves, we had summoned the relevant record which has been produced by the learned additional chief standing counsel. On a perusal thereof, we find that after submission of the reply by the petitioner to the charge sheet, no date was fixed by the inquiry officer for holding any inquiry, nor any inquiry was held by him. No material has been produced before us by the learned additional chief standing counsel showing any inquiry having been held by the inquiry officer as is required under law. It appears that the inquiry officer has prepared and submitted the inquiry report straight away after submission of reply by the delinquent. The documents placed before us by the learned additional chief standing counsel reveal that the inquiry officer issued a letter dated 18/7/2011 annexing therewith the charge sheet to the petitioner seeking his reply to the same by 10/8/2011. By the said letter, the petitioner was also required to inform as to whether he wanted any personal hearing and also if he wanted to examine and cross-examine any witness, then the name as also a brief note on the points on which such examination or cross-examination was required. It was stated that if the reply was not submitted, then it would be deemed that the petitioner had nothing to say in respect of the charges, and accordingly the inquiry would be conducted and the state government would be informed. The contention of the learned additional chief standing counsel that as the petitioner did not state in his reply that he wanted any personal hearing, nor did he mention the name of any person whom he wanted to examine or cross-examine. Therefore, the inquiry officer prepared the inquiry report and submitted the same before the state government. Learned additional chief standing counsel contends that sufficient compliance of the rules of procedure as prescribed under law has been made for imposing major punishment and principles of natural justice were duly adhered to. We are unable to accept the contention of the learned additional chief standing counsel. Even if the delinquent employee does not request for personal hearing, the burden of proving the charges normally being upon the department, the inquiry officer was under obligation to fix a date for such inquiry with information to the delinquent and to conduct inquiry wherein he was required to examine documentary as well as oral evidence in support of the charges. Even if the delinquent employee did not participate in the inquiry officer was duty bound to discharge his obligation as an inquiry officer of ascertaining the truth in respect of the charges leveled against him on the basis of evidence as to whether the same are proved against him or not. Even if the delinquent does not demand personal hearing or does not give the names of witnesses with brief synopsis of points on which he wishes to examine or cross-examine the witnesses, the inquiry officer is not absolved from fixing a date of inquiry with intimation to the delinquent. In either eventuality, he is required to hold inquiry if delinquent is present in his presence, if he is absent ex parte. If oral evidence is referred in the charge sheet, same is required to be recorded, examined. If not, even then the documentary evidence is required to be examined in the light of the charges for ascertaining the truth in respect thereof. The delinquent is also entitled to be intimated the date for oral inquiry wherein the inquiry officer should confront the delinquent with the charges and the evidence in support thereof, put relevant queries to him, elicit and record his response in respect thereof. Such oral inquiry is necessary as it gives an opportunity to the delinquent to explain his conduct and to the inquiry officer to have a better perspective of the controversy, as it is not always possible to discern the truth from written replies and documents, which may not necessarily convey the complete truth. Stop.